let's get right at it with former U.S. Deputy Assistant Attorney General, the one and only Tom Dupree. Tom, we need you on this. It's so good to see you. Let's get right at the facts, the nuts and bolts of the opening arguments in the Manhattan DA's hush money case against former President Trump. Because, you know, from where we sit, it should fall apart on reasonable doubt with the jurors, Tom. And that means Trump walks. I mean, maybe we're wrong, but what did you think of the opening arguments? We heard a lot of rhetoric, but what actual proof and evidence do we see so far from Bragg's team of a, quote, criminal conspiracy by Trump to steal the 2016 election from Hillary Clinton and cover it up?
Yeah, Liz, you're absolutely right. Today was a fascinating day. It's one we've all been waiting for. Today was the day when the prosecutors really had to start showing their cards about how they're going to prove this case against Donald Trump. What we heard today, to my mind, was a little different than what we've heard before. Today, they really hit big on the notion that there was a conspiracy to disrupt the election. That's a little bit of a different branding, a little bit of a different framing than we've heard before. But according to the prosecutors, what they're going to tell this jury over the next 6 weeks is that Trump was part of a larger conspiracy to really suppress the Stormy Daniels story in order to influence the elections. It's a pretty tall order for the prosecutors to prove, but that seems to be how they're going to try this case. Yeah,
it's a lot of rhetoric, but where are the facts? Show the letter again from Michael Cohen's lawyer. Michael Cohen's lawyer wrote to the Federal Election Commission in 2018. His letter reads, quote, "Neither the Trump Organization nor the Trump campaign was a party to the $130,000 payment to Stormy Daniels. Neither the Trump campaign nor the Trump Organization reimbursed Michael Cohen for the payment directly or indirectly." I mean, that sounds like reasonable doubt, Tom. Yeah, a lot of talk about the testimony from the National Enquirer publisher David Pecker about tactics he used to supposedly bury negative stories about Trump. But reasonable doubt is that's about the nuts and bolts of the case. What do you think of that letter?
It is. And look, reasonable doubt, the standard American law, is the highest burden of proof imposed under American law. This is an exceedingly high standard for the prosecutors to prove. I think it's also interesting that so much of the prosecution's case is going to turn on what Michael Cohen has to say. And what we heard today from the Trump defense team, Liz, was that they are going to be going after Michael Cohen with double barrels. They went after him hard today. They said he was a liar, someone who couldn't be trusted. And so they really did their best to cut at the heart of what I think is going to be the prosecution's case for the next month or two.
So, yeah, I mean, the Trump defense noting that Cohen is a perjurer, that Cohen himself admitted he has lied under oath more than once in a federal court, and he's accused of making material false statements to prosecutors in the FBI. Also, Stormy Daniels supposedly had a grudge against Trump after Trump didn't put her on the Apprentice cast in 2007. We don't know if that's true. But come back to this. So we're talking about a federal campaign a charge. This is what Manhattan DA is talking about. He's claiming a federal campaign violation by Trump. But, Tom, it's built on an expired books and records state misdemeanor that is already years past the statute of limitations, a bookkeeping record made in 2017 after the 2016 election. Tom, if it was such a big federal violation, why did the DOJ and FEC already drop it? And why wait 7 years to bring it?
Those are all great questions. And look, I think the prosecutors are going to have to provide credible answers to those questions to the jury. The prosecutors have a tall task ahead of them. To your point, they are going to have to prove not just that there was a records violation, but also that the purpose of the records violation was to violate federal election law. As we talk about this, not only are they going to have facts to actually prove this case, but they're also going to have to be able to explain this to the jury in a way that the jury can understand it. These are common sense New Yorkers who are hearing this case. And if the prosecutors tell a story that's full of legalese and complexities and old documents that don't make any sense, yeah, I promise you, this jury, even if they're not the biggest fans of Donald Trump, are not going to convict him.
Yeah, and there are two lawyers on the jury. Let's move on to this story. New York Attorney General Letitia James just lost again in court. A judge said Letitia James cannot invalidate former President Trump's $175 million bond that Trump had to put up first before he could appeal the New York civil judgment. You know, an appeals court already cut that initial fine by more than half, down from $454 million down to $175 million. So now Trump can appeal? Is that what's going to happen?
I think that's exactly what's going to happen. And look, this attorney general is giving Trump no quarter. She has been fighting him at every turn. But what we've seen, Liz, is that ever since this trial ended, it's been one victory for Trump after another. To your point, he got the appeals court to cut the amount of the bond. He just successfully fended off the attorney general's attempt to basically blow up his bond. And so he may have very, very different results when this verdict or this judgment from the trial judge goes up on appeal. He's going to have a whole brand new slate of judges who are going to be looking at the evidence independently, and they may see that evidence very, very differently than the trial judge did.
Interesting, Tom. It ain't over till it's over. Tom Dupree, thank you.
For
Good
sure.
expertise. Appreciate you so much.